Good afternoon, students. Today is Tuesday, 1 February 2022. This will be the second of three lectures on the essay by Lon Fuller, which remember is a hypothetical legal case. Let's begin by looking at what's posted on Canvas. I'm not going to go through all of it, but I told you most recently that I put up a timeline of the events in the cave by Peter Suber. Since then, I've put up a handout entitled Hard and Easy Cases at Law. Make sure you read that and make sure you know the difference between a hard case and an easy case. It's only a one-page handout. After that, I posted an essay by Frederick Schauer, who is a law professor at the University of Virginia, or at least was at the time of the publication. This article is optional reading, and I put those words on Canvas. Optional reading means I recommend that you read it, but it's not required, and I won't test you on it. But I think in this case in particular, reading this short essay by Fred Schauer will really help you understand the case better than you would without reading that essay. So it's optional reading. I recommend that you read it, but I won't test you on it. The next item is a short two-page article on jury nullification by a man named Linder. Jury nullification, as you know by reading that handout, is allowed in the legal system, but it's kept secret. Juries always have the power to disregard the law and render a verdict that is independent of the law because they believe that a guilty verdict, for example, would be unfair. And the reason I posted that for you, besides bringing this to your attention, is that the jury in the hypothetical case in Newgarth, the jury obviously was concerned, as was the trial judge. They were obviously concerned that an injustice was about to be done to these men. These four defendants, as you know, killed and ate one of their fellow spelunkers. The jury rendered a verdict of guilty and then joined the judge in communicating with the chief executive of Newgarth. And what they advised the chief executive to do is to commute the sentences from death by hanging to 6 months in prison, which had probably by that time already been served. Now, I wonder why the jury didn't simply nullify. Again, I realize it's a hypothetical jury, but it's strange that Fuller didn't even mention this as a possibility. The jury could have, in that case, or in any case, the jury could have disregarded the law, which obviously the jury felt applied to the facts of this case. The jury could have disregarded the law and rendered a verdict of not guilty. And that way the four men would not have been sentenced to death and would not have risked death in the judicial system. So anyway, read that article over. It's very interesting, the concept of jury nullification. In fact, the next item by an op-ed column by Paul Butler is also on the topic of jury nullification. Butler has argued, not only in this op-ed, but in other places, he has argued that the laws against drug use are unjust, in part because they have a disproportionate impact on young men of color, and women, I suppose. And so Butler says to jurors, you have the power to nullify the law. And he recommends that in drug cases, especially against blacks, that the jury render a verdict of not guilty, in spite of what the law may say and in spite of the facts of the case. So those two articles together are designed to help you understand what jury nullification is. And there's, of course, a lot more that's been written about it. You can do your own research if you want, but those two items struck me as fairly straightforward and easy to understand. Okay, the only other item that I've posted on Canvas so far, as of right now, is the next reading in the course, which will take up a week from today. It's the article by Stephen Wise entitled Of Farm Animals and Justice. So that article is now posted. We won't be starting it for another week, but you may want to get started on it in the meantime. So I put it up early. And there will be a few more items posted that have to do with that article. Remember, our first exam is coming up pretty quickly now. Today is the 1st of February, and the exam is on the 17th of the month, which is only 16 days from today. And keep in mind that this exam will be given during the normal class hours. It will be given on Canvas, but the exam will begin at 8 o'clock in the morning, which is the time we usually meet in the classroom, and it will end at 9:15. It's a 75-minute exam. So if you've had a course from me online, you know that I, up until now, have been giving students a 12-hour window in which to take the exam. I don't do that anymore. I think that was abused. I think it opens up the door to cheating. And I now expect you to go in during the same time you would be in the classroom taking the exam, except you're going to be doing it on Canvas. Okay, so make a note of that. On the 17th of this month, at 8 in the morning until 9:15, you will be in Canvas taking your first exam. Okay, remember also that UTA has dictated or decreed that we do our courses online until the 4th of this month, which is, I believe, Friday. Well, we don't meet on Friday. We wouldn't meet again until the 8th. So unless we hear otherwise from the university, we're supposed to be back in the classroom 1 week from today. Now here's the complication. At least one of the students in this class has a legal reason not to go to class. And the university has requested that I make my lectures available to this or to these students in a recorded format. So what I may do, I don't know how long these students or this student, I don't know how long they will need before coming back into the classroom. I hope it's very soon, maybe only 1 week, because I want to get back into the classroom as quickly as possible doing live lectures. And I'm not going to do both. I'm not going to record a lecture from home, which is what I'm doing right now, and do that very same lecture live in the classroom. I will not do that. So it's one or the other. Either I will lecture live in the classroom, and I expect everyone to be there, and for those students who can't make it, you will, as always, get the notes from another student. Actually, I'm posting my lecture notes, which I assume would be better than any student's notes. So at this point, I'm not sure what's going to happen. I think starting next week on the 8th of February, I'm going to continue posting recorded videos like I'm doing right now for 1 more week. And then I'm going to stop doing recorded videos and go back into the classroom. I think that's a fair compromise. So let's play it by ear. I'm going to do a recorded video twice this week, today and 2 days from now. And then a week from today, we'll see what has happened, what UTA says about going back in the classroom. To this moment, we haven't heard from UTA that we're definitively going back into the classroom on the 4th or the 8th of this month. So I assume that we're going to get some kind of instructions from UTA very soon, probably this week. Okay, enough about the preliminary matters. Let's get to our topic for today. We're discussing the famous article by Lon Fuller, The Case of the Spelunkian Explorers. I divided it up into 3 class periods. Most recently, on the first day, the first lecture, we covered the facts of the case and the first of 5 judicial opinions, the one by Chief Justice Truepenny. Today we're going to do 2 more opinions, the opinion by Justice Foster and the opinion by Justice Tatting. And then later this week, 2 days from now, we will complete the article by discussing the other 2 opinions by Justices Keene and Handy. So let's get started. We're going to begin today with the opinion by Justice Foster. Now, the first thing Justice Foster does is chastise the Chief Justice for, quote, adopting an expedient at once so sordid and so obvious. Now, Justice Foster is not happy with this case. Justice Foster believes that these defendants are not guilty of any crime. He thinks that any interpretation of the statute that leads to that result is unacceptable, indeed is absurd. And he's critical of Justice Truepenny, Chief Justice Truepenny, for applying the statute straightforwardly to the facts of the case and concluding that the lower court ruling is to be upheld or affirmed. Justice Foster thinks that that would be a great injustice. Now, arguably, Justice Foster is being result-oriented. Do you remember our discussion of what that means? A result-oriented judge decides, without doing any legal research, really without doing any thinking at all, decides who should win the case, and then starts doing legal research to provide a justification for that result. Right? That has things backward. You should not decide first who should win and then do your research to supply a justification for that result. What you should do is keep an open mind about who should win, do your research, see what the law is, apply the law to the facts of the case, and then reach a conclusion, either for the plaintiff or for the defendant, either for the appellant or the appellee. So what I'm saying is, arguably, Justice Foster did things backward. He decided that these men were not guilty, and then he figured out a rationale that supports that result. Okay, so I'm offering a mild criticism of him. And you'll see that Justice Tatting has some disparaging things to say about Justice Foster as well. Okay, so what is Justice Foster's ruling and what is his justification for it or his rationale for it? Justice Foster makes 2 separate and independent arguments for reversal of the convictions and death sentence. 2 different arguments. He is arguing in the alternative, as lawyers put it. So I'm going to take these arguments one at a time, and I want to make sure you understand what he's saying. Both of them have the same result, the same conclusion, which is that the defendants are not guilty, and therefore the trial court ruling must be reversed. Okay, the first argument, and if you're following along in my lecture notes, I'm near the bottom of page 5, where it says, there is a failure of presupposition. Okay, I've got a couple of items on my screen. Let me just get rid of them. One of them wants me to upgrade my operating system. One of them says I have had no backups for 30 years or something. Okay, so according to Justice Foster's first argument, there's a failure of presupposition. Now let me explain what's going on here. Justice Foster is alluding to a famous theory of politics or law. The theory goes back at least to Thomas Hobbes, the British philosopher. Now, I can't give you a long exposition, obviously, of Hobbes's theory, but let me give you the quick and dirty version. Hobbes assumed that at some point in human history, people lived in a state of nature, a state where there's no government, no law, no courts, no police, nothing. They were in a state of war against one another. Each person did whatever he or she thought was necessary to stay alive, to defend whatever possessions he or she had, and so on. Now, Hobbes claimed that this state of nature, this condition of war of by all against all others, would be very undesirable, to say the least, and that people would eventually agree among themselves to create a sovereign. That's what Hobbes called it, a sovereign, a political ruler. They would give the sovereign power to rule over them. And in return, they would relinquish their natural liberty to do as they please. So the idea is that individuals would be highly motivated to escape from the state of nature, the state of lawlessness, and they would form a government. Now that's going to have a cost. They're going to have to give something up in order to get the security of living in a society with a sovereign. What they give up is their liberty. And Hobbes thought that this would be a desirable trade. These people would be happy to give up their individual liberty to do as they please in order to get the security of living in a society where if someone stole from them or harmed them, they could call up the authorities, the sovereign, and the sovereign would find and punish those who had perpetrated the misdeeds. So that's the Hobbesian picture. Society is founded in a contract between individuals. Everyone benefits from living in a political society with government. Okay, let's get back to Foster. Foster is saying that in the Hobbesian manner, the purpose of society is to allow people to live together peaceably and harmoniously. Unfortunately, in this case, the case of the spelunkers, unfortunately, they're in a condition of lawlessness. They are no longer able to live together harmoniously because of their condition. They're all going to die unless one of them is killed and consumed by the others. So, according to Justice Foster, one of the preconditions for civil society is missing in this case. And specifically, the precondition that's missing is the ability to live together peaceably without harming one another. So what is the upshot of this? According to Justice Foster, these men no longer live in civil society. They have in effect reverted to the Hobbesian state of nature, where anything goes. And they adopted a procedure whereby one of them would die in order that the others may live. So Justice Foster is saying that the state of nature describes the condition of these men, and therefore the law of Newgarth doesn't even apply to them. Right? They no longer live in civil society. They're back to the state of nature where literally anything goes. So the first argument made by Justice Foster is simply this: law presupposes a possibility of harmonious living. That presupposition of law does not apply to the facts of this case. Therefore, the law of Newgarth does not apply to what these men did. Therefore, they are not guilty of violating the statute that prohibits willful murder. Therefore, the trial court ruling of guilt and the sentence of death must be reversed. So that's the first argument. It goes into the nature of law, the purpose of law, and Justice Foster is saying that the purpose of law can't be fulfilled in this case. Therefore, what these men did is not a violation of the law of Newgarth. He says on page, well, I don't have the page here, it's approximately 622. He says, under those principles, that is the principles of the state of nature, they were guiltless of any crime. These men were, these four defendants. He says on page 622 that these men drew, quote, a new charter of government appropriate to the situation in which they found themselves. Once they reverted to the state of nature, they were able to enter into any contract that they pleased. And they did so. They adopted an agreement, all of them, including the one who ended up being killed and eaten, Wetmore. They adopted a plan whereby dice would be thrown, and whoever got the lower number would be sacrificed for the sake of the others. So it's very Hobbesian in its spirit, isn't it? So let's look at my reconstruction of the argument on page 6 of my lecture notes. The first premise is a Latin expression, and I'll pronounce it. I may be mispronouncing it, but I'll do my best. Cessante ratione legis, comma, cessat et ipsa lex. And I assume that, like me, you don't know Latin, so you need a translation. It's usually translated as follows. The reason of the law ceasing or ending, the law itself also ceases. Okay? It makes sense. If the rationale for law ends or ceases, then so does the law itself. In other words, the foundation of the law has been destroyed. Therefore, the law itself comes crumbling down. If you destroy the foundation of law, you have no law. That's what that means, in effect. All right, Foster's second premise gets more specific. He says the reason for positive law ceases in this case. And I explained why a moment ago. The purpose of law, the point of law, is to allow people to live together peaceably or harmoniously. And that is no longer possible given the situation in which these men find themselves after the landslide. Okay? Now, what follows from the premise, the two premises? Well, 3 follows. Therefore, 3, positive law ceases in this case. Positive law is the law posited or laid down by some government, in this case, Newgarth. And positive law is contrasted with natural law. Natural law is the law that exists in nature, independently of any government or civil society. So there's no positive law in this case. The law of Newgarth, in other words, does not apply. So what's the alternative? Well, that brings in premise 4, a new premise. The only alternative to positive law is natural law, the law of nature. So Proposition 3 says there's no positive law to be applied. 4 says the only alternative to that is natural law. Therefore, natural law applies. Now comes a new premise, 5. Natural law allows the act performed by the defendants. Why? Because in a state of nature, as Hobbes points out, individuals are free to contract with one another, to agree with one another. And that's what these men did. The 5 of them agreed to a procedure whereby one would be killed to nourish the others. And so the grand conclusion of this argument is 6. No crime was committed. So what I tried to do here is unpack and restate Justice Foster's reasoning. I tried to make explicit all of his assumptions about the case. Now, there could be criticism of this argument. In fact, Justice Tadding will proceed to criticize it, as will Justice Keene, as you'll see. But I'm going to hold off on those criticisms for now. I just want to make sure you understand the argument. All right? So let's move on to the second of the 2 arguments made by Justice Foster. He thinks that this argument shows that the lower court ruling must be reversed and the defendants freed. Now, that argument alone would suffice to reverse the trial court. You may wonder, why did Justice Foster proceed to make a second argument? Well, lawyers often do this. It's called arguing in the alternative. Maybe there's something wrong with Justice Foster's first argument. He may think it's a strong argument, but maybe there's something wrong with it. And if there is, then it would be nice if he had another argument to fall back on. It's a fallback position. The more arguments you have in favor of a certain conclusion, the stronger is the case for that conclusion. And so Justice Foster made two separate and independent arguments for the same conclusion, which is that the trial court ruling should be reversed and the defendants freed and therefore not punished. So let's look at the second argument. Many people think that this argument about to be made by Justice Foster most closely reflects Fuller's own view. And I agree with that. I've read Fuller's books and articles, and when I first read this case years ago, my first thought when I read Justice Foster was, that sounds like Fuller. At least the second argument I'm about to go over with you. And it's no coincidence, I think, that both of the names start with F, Fuller, Foster. But Fuller never says that Foster's views represent his own views, and it's really not important that they do or whether they do. So I just threw that in as kind of obiter dicta, just words. But it does give you something to think about. If you were wondering which of these justices represents Fuller, I'm suggesting that maybe it's Foster. Probably it's Foster. And I'm not the only one who thinks that. In fact, I posted an article by Fred Schauer. I told you about it a few minutes ago. Schauer also concludes that Foster is Fuller. Okay, let's look at that second argument. The second argument made by Foster goes into the nature of purposes. Right? Laws are made for a purpose. When the legislature enacts a bill into law and it's signed into law by the governor, each of the legislators and the governor or president, each of them must have some purpose in mind for enacting the law. So according to this view of Justice Foster, the job of a judge, when a statute is not clear, and maybe even sometimes when it is clear, is to try to figure out the purpose of the statute and then be faithful to that purpose. So what is the purpose in general of any criminal law? Well, there are different theories of that. Some people say that the purpose of the criminal law is simply to pay people back for their misdeeds. That's called retribution. Retribution says you've committed a crime, that alone justifies us in punishing you, even if nothing good comes of the punishment. Okay, it's retribution for retribution's sake. That's one purpose of the law, of the criminal law. Another purpose of the criminal law that's widely defended is deterrence. When we punish people for violating the criminal law, we are sending a message to everyone in society. This is what happens when you break this law, or when you break any law. And the hope is that people will learn from that. People will read about someone who has broken the law and is being punished for it. They will reason as follows. I wouldn't want to be put to death. If I break this law, there's a very good chance I will be put to death. Therefore, I will make sure I don't break the law. When someone reasons that way, that person is being deterred by the threat of punishment. So that's a second purpose of criminal law. There are others. Let me mention one other. It's called rehabilitation. To rehabilitate someone or something means to rebuild it. So the idea is that when people break the criminal law, something's going wrong with them. Either they are unemployable and they broke the law in order to sustain themselves, to feed themselves, for example. Maybe they have mental illness and they're unable to control their impulses, so they break the law. That sort of thing. Well, if we take someone like that who has broken a criminal law and confine them to prison or jail for a period of time, we can do things to them or for them so that when they are released from prison or jail, they will no longer have a desire to break the law, either because we have taught them valuable skills so that they can work and support themselves and therefore not have to resort to crime, or because they had some kind of mental illness. We may have given them treatment for their mental illness. They may now be on medication that helps them control their impulses so that when they're released from prison or jail, they no longer even have a desire to break the law. All of this is called rehabilitation. And that's usually cited as one of the purposes of criminal law. So we have retribution, deterrence, and rehabilitation. 3 different purposes of the criminal law. So Justice Foster is of the view that we should look at the purpose of the statute, the murder statute, and if the purpose would not be fulfilled by punishing these defendants, then we shouldn't punish them. We don't just look at the words like Chief Justice Truepenny did. Don't just look at the words and see whether they apply to the facts of this case. That's simplistic, according to Justice Foster. That's a mindless, literal reading of the statute and a literal application of the statute. We should do something more sophisticated than that. We should try to figure out the purpose of this statute or of any criminal statute and then ask this question: would the purpose of the statute be furthered or fulfilled if we applied it to these defendants? Yes or no? And if the answer is no, then we shouldn't apply it to them and we shouldn't punish them. So Justice Foster, now that he has described this process of appealing to the purposes of the laws, Justice Foster says one main purpose of the law is deterrence. And I described that to you a moment ago. Deterrence. Would these men have been deterred by the threat of punishment? Well, the answer is obvious. No, they were not deterred. They knew, presumably, that when they killed Roger Wetmore, they were committing murder. Did that deter them from acting? No, it did not. They were so hungry, so desperate, so determined to live that they killed Wetmore anyway. These men, in their condition, were undeterrable. Let me say that again. Undeterrable. They were incapable of being deterred because of the desperation of their situation. So, if one of the main purposes of criminal law is deterrence, and if these men were not deterrable, then it would be pointless and self-defeating to apply the criminal law to them, as was done by the trial court. So, once again, Justice Foster has concluded that these men are not guilty and that the verdict of the trial court must be reversed. It's because the purpose of the criminal law would not be furthered by punishing them. So, if you'll turn to page 7 of my lecture notes, you'll see my reconstruction of this reasoning. What I'm trying to do is break it down step by step. And in doing so, I want to display all of the assumptions that Justice Foster is making so that we can examine them. Sometimes people make assumptions that are actually false. And if the assumption was never made explicit, we might not notice that we're assuming it. So the purpose of reconstructing someone's argument is to make all of these assumptions that are essential to the argument explicit. Bring them out into the light of day so that we can look at them, think about them, and evaluate them. We want to decide are the assumptions true or false? Because if any of the assumptions Justice Foster makes happens to be false, then his argument fails. All of his assumptions, all of his premises have to be true in order to give us reason to accept his conclusion. So here is my reconstruction of the argument. Let me just read it over, and I'll pause to explain things as I go. Premise number one. According to Justice Foster, statutes are to be interpreted in light of their purpose or purposes. There may be more than one purpose, but maybe just one purpose. But however many purposes there are, we need to bring them out and interpret the statute in light of the purposes that the legislators had when they enacted the bill. All right, premise two. According to Justice Foster, one purpose of a criminal statute, such as Section 12A, is to deter people from violating it. What do you get when you put 1 and 2 together? You get 3. 3 is the first conclusion. A criminal statute applies to a case only if the defendants in that case were deterrable. You see why that follows from 1 and 2? And remember, deterrable means capable of being deterred. It doesn't mean that they were actually deterred. It means that they could have been. It was possible for them to be deterred. Now, Foster thinks that he has established Proposition 3. He's going to continue arguing now by adding a new premise, 4. 4 says the defendants in this case were undeterrable. And I've explained why he might think that. They were undeterrable because they were desperate. The desire to preserve their lives overwhelmed their desire not to be punished. So it's as though they had no free will. They didn't even act willfully. Now, what do you get when you put 3 and 4 together? Let's read them again quickly. A criminal statute applies to a case only if the defendants in that case were deterrable. 4 says the defendants in this case were undeterrable. What follows from 3 and 4? 5 does. 5 says the criminal statute in this case, which is Section 12A, does not apply to the defendants. The statute does not apply because a statute applies only if the defendants are deterrable, and these defendants were not deterrable. Now, Justice Foster's not done arguing yet. He wants to draw the grand conclusion. From Proposition 5, all by itself, he infers that the defendants are not guilty. Why are they not guilty? Because the statute does not apply to them. So that seems to me to be Justice Foster's argument. He's trying to persuade readers of his opinion that his conclusion is correct. His conclusion is that the lower court ruling is erroneous and must be reversed. Now, let's shift gears a little bit. Now that we've looked at Foster's 2 arguments, Justice Foster appears to be worried about something. He appears to be worried that maybe he's not being faithful to the law. Every judge wants to be faithful. It's called fidelity. It comes from the Latin word fides, which means faith. So fidelity just means faithfulness. Judges are supposed to be faithful to something, to the law. But that raises a question. Is a judge to be faithful to the literal wording of the law or to the spirit of the law, which we could interpret as the purpose? Chief Justice Truepenny was faithful to the wording of the law, the literal wording. Justice Foster thinks that's a mistake. A judge, Justice Foster would say, should be faithful to the spirit of the law. Whenever the spirit of the law and the literal meaning of the law come apart, the judge should go with the spirit, be faithful to the spirit, and ignore the letter. So Justice Foster thinks that Chief Justice Truepenny made a mistake. He was faithful to the wrong thing. If he had paused to ask about the purposes or the spirit of the law, he may well have reached a different decision than he did, one that agrees with Justice Foster. Now, how does Justice Foster support this claim that a judge should be faithful to the spirit of the law? Let's take a look at some of the things he says. I'm referring now to page 625 of Fuller's article. Justice Foster says the following: there are those who raise the cry of judicial usurpation whenever a court, after analyzing the purpose of a statute, gives to its words a meaning that is not at once apparent to the casual reader who has not studied the statute closely or examined the objectives it seeks to attain. Let me say emphatically that I accept without reservation the proposition that this court is bound by the statutes of our Commonwealth, and that it exercises its power in subservience to the duly expressed will of the Chamber of Representatives. Now, that's the legislative body of Newgarth. That's what they call it, the Chamber of Representatives. So, I'm going to come back and read some more in a moment, but let me comment on what we've read so far. Justice Foster is saying, I'm not one of those judges who just ignores the law. We're going to see an example of that later. Justice Handy says, we judges can rule any way we please. We can take account of anything we want, including public opinion polls, common sense, whatever. Now, Justice Foster, without referring to Justice Handy, is saying, I reject that approach. I don't believe that we can do just anything we want to reach whatever result we want. We're bound, we judges are bound to enforce the law enacted by the legislature and signed by the executive. Right? We judges are not lawmakers, we're law appliers or law enforcers. But that leaves room for a judge to ask, what exactly am I to enforce? The literal meaning of the words given to us by the legislature, or the spirit of those words, the underlying purpose of the law? And that, of course, is Justice Foster's position. So let's continue reading. The line of reasoning I have applied above raises no question of fidelity to enacted law, though it may possibly raise a question of the distinction between intelligent and unintelligent fidelity. Now, when I first read that, I thought, ouch. He's criticizing Chief Justice Truepenny, isn't he? That's the only other opinion we've read so far. Justice Truepenny, I think, according to Justice Foster, was giving an unintelligent reading of the statute, whereas Justice Foster thinks that Justice Foster, is giving an intelligent reading to the statute. In other words, Chief Justice Truepenny was faithful, but he was faithful to the wrong thing. Justice Foster is also faithful, but he thinks he's being faithful to the right thing, which is the purpose of the statute, the spirit. Now, here are some analogies I think you'll find interesting. The language is somewhat offensive, but this is what he wrote. This is what Justice Lon Fuller wrote. The stupidest housemaid knows that when she is told, quote, to peel the soup and skim the potatoes, unquote, her mistress does not mean what she says. Now, fill in the details. You've got the mistress of the household and the maid. The mistress is telling the maid, maybe she's a little bit distracted or agitated. She says, peel the soup and skim the potatoes. Now, if the maid followed those instructions literally, that would be absurd, right? How do you peel soup anyway? How do you skim potatoes? It makes no sense. So even the stupidest housemaid understands what happened. There was a misfire. The mistress of the house didn't intend to say what she said. So the housemaid could have approached her and said, "Excuse me, here's what you said. Do you want me to do what you said or what you meant? Because I think you meant something other than what you said." The mistress then would say, "Oh, I'm sorry. What I meant was peel the potatoes and skim the soup. Thanks for correcting me and allowing me to correct what I said. I said something incorrectly, erroneously." So the housemaid, even a stupid housemaid, according to Foster, knows enough or has enough sense to go by what was meant rather than by what was said, to go by the purpose of the utterance rather than the literal meaning of the utterance. Okay, that's the first example. Here's another one. The stupidest housemaid also knows that when her master tells her to, quote, "drop everything and come running," unquote, he has overlooked the possibility that she's at the moment in the act of rescuing the baby from the rain barrel. So, the situation, the baby has fallen into the rain barrel. Luckily, the maid is right there on the scene, sees it happen, reaches in, pulls the baby out of the water. We can assume the baby would drown within moments. It was lucky that the maid was there when it happened. Just then, the master of the house yells out to her, "Drop," what does he say? "Drop everything and come running." Now, literally, if the maid followed those instructions, she would drop the baby back into the water and come running. And by the time she got back or explained what was going on, the baby might be dead. So the housemaid, using her own intelligence and common sense, would disobey the orders. She would not drop what she's doing and come running. She might secure the baby away from the rain barrel so the baby won't drown, maybe then put the baby down and come running to the master. Or perhaps she could hold on to the baby and run to the master. Either way, the baby is not in danger of drowning. So Foster is giving two examples of where somebody said something erroneous, somebody said something other than what he or she meant to say, and the recipient of those instructions is left with some discretion to interpret them in a commonsensical way. So let's finish up this paragraph. Foster writes, "Surely we have a right to expect the same modicum of intelligence from the judiciary, from judges. The correction of obvious legislative errors or oversights is not to supplant the legislative will, but to make that will effective." So, Foster's picture of the responsibility of a judge is as follows. The legislature makes the law. It's the lawmaking body. The job of a judge is to give effect to the law as enacted. Sometimes the legislature misstates things or omits to state relevant and important things. When that occurs, the job of the judge is to fill the gaps, right? To correct what was mistakenly said by the legislature, or perhaps to fill in gaps. Now, I think Justice Foster is suggesting that the legislature could not have had in mind punishing these defendants. The legislature did not put an exception in the statute for cases of necessity. But Justice Foster, I think, is going to read an exception like that into the statute. In effect, the legislature built an exception into Section 12A. And that exception is whenever you are acting under compulsion, you will not be found guilty of Section 12A, of violating Section 12A. You will not be found guilty of murder. So Justice Foster thinks that he's being faithful to the law, not the law as it's written, which may be stupid or incomplete, but the law as the spirit of the law, the purpose of the law. That's what the judge should be faithful to. All right, so here's how he concludes his opinion, page 626. I therefore conclude that on any aspect under which this case may be viewed, these defendants are innocent of the crime of murdering Roger Wetmore, and that the conviction should be set aside. That's another way of saying reversed. So Justice Foster now has arrived at a conclusion and supported it. The conviction and the sentence of death are reversed. They're to be set aside. So what do we have? What's the tally so far? We've had 2 justices out of 5. We'll look at the other 3 in due course. The 2 who have now issued rulings and opinions are split. Chief Justice Truepenny voted to affirm the convictions and the sentence of death. Justice Foster voted to reverse. So at this moment, it's 1-1. Let's move on. We have one more opinion to look at today, and that's Justice Tatting. Justice Tatting expresses his ambivalence about this case several times. Now, what is ambivalence? Ambivalence means you're torn. You're torn you're pulled in 2 directions emotionally. On the one hand, you want to go this way, but on the other hand, you're pulled this way. So you're being pulled in 2 different directions. And sometimes that leads you to be indecisive. You don't know which way to go. What is the ambivalence in particular? Well, Justice Tatting has sympathy for the defendants. He thinks that they did nothing wrong. Anybody else would have acted the same way, probably. How can we blame them for what they did when we would have done it as well? What's the biblical expression? There, but for the grace of God, go I. Anybody reading the facts of this case would probably say, you know what? If I were in that horrible situation, I might well have done what they did. And if I weren't chosen to be killed, I would now be on trial for murder and sentenced to death and in danger of losing my life. So Justice Tatting, first of all, has sympathy for the defendants. Secondly, he has abhorrence or disgust for what they did. Killing and eating a human being disgusts him. It's abhorrent to him. So on the one hand, he's drawn to the defendants and is sympathetic to their plight. But on the other hand, oh my God, what did they do? It's so disgusting what they did to this poor man, Wetmore. He says he wishes that they had been charged with something other than murder. For example, what if Newgarth had a law prohibiting the eating of human flesh? Now, that's not the same as murder, because that law would be violated by someone who came upon a dead body and ate some of the flesh. So if Newgarth had a separate law that simply forbade or prohibited eating human flesh, presumably the punishment would be much less than death. Maybe it would be 5 years in prison or something. So what Justice Tatting is saying is, darn it, I wish the legislature had seen fit to have a law such as one against eating human flesh, because then we could uphold that law and apply that law with a clear conscience, because the punishment would be so much less. Unfortunately, there is no such law, and we judges can't just make one up. We're not lawmakers. So we're stuck either enforcing the murder law against these poor men or being lawless and unfaithful to the law. And pretty clearly, Justice Tadding is not going to do that. He does not want to be unfaithful to the law. So he's in a very difficult position. He's ambivalent. He's torn between affirming and reversing the conviction and the sentence of death. Justice Tadding, perhaps by way of venting his frustration and his feelings, he spends a great deal of his opinion criticizing Justice Foster. So he says that Justice Foster's opinion is, quote, shot through with contradictions and fallacies. He says, for example, referring to Justice Foster's state of nature argument, if indeed these defendants escaped the laws of Newgarth when the landslide occurred, if they were in a state of nature once the landslide occurred, where do we, the judges of the Supreme Court of Newgarth, get the authority to sit in judgment of them? We are judges or justices of Newgarth, which is a civil society. We're not judges or justices of the state of nature. There are no judges in the state of nature. There are no justices. There's no government. There's no law. There are no courts. There are no police officers. Right? It's a state of all, a war of all against all, where people are free to do as they please, including kill others. So the first point Justice Tadding makes is to ridicule Justice Foster by saying, okay, if these men are in a state of nature, as you say, Justice Foster, then we have no jurisdiction over them. We are duly impaneled judges of Newgarth, and our job is to enforce the laws of Newgarth. If these men were in a state of nature, then we have nothing to say about what they did, and we have nothing to do with them. We have no power or authority to issue any rulings with regard to them. So that's his first point. He makes some other points, among which is that there is more than one purpose of the criminal law. Justice Foster, as you recall, put a lot of weight on the deterrence purpose of criminal law. But Justice Tadding points out that there are other purposes besides that. Retribution, which is paying people back for their wrongs, and rehabilitation, which is changing people in some way so that they no longer have a desire to commit crimes. And it may well be that even if we resort to the purposes of Section 12A, that one or more of those other purposes may be fulfilled by punishing them. Retribution, for example. What these men did in killing and eating Wetmore is a violation of the law, and they should be paid back for it. That's retribution, the payback theory of punishment. So the second point made by Justice Tadding is to criticize Justice Foster's purpose argument, the second of the two arguments, by calling into question the assumption that there's only one purpose, namely deterrence. There may be other purposes, and those other purposes may point toward affirming the conviction rather than reversing it. And so, in conclusion, Justice Tadding says on page 630, resorting to the purposes of the criminal law creates a, quote, quagmire of hidden difficulties. It's as though Justice Tadding is saying that Justice Foster hasn't really thought things through. Be very careful if you resort to the purposes of the law, because first of all, there could be more than one purpose, and they could point in different directions. And that's a quagmire. Now you've got to figure out which purpose is most important. And that could open up a lot of other questions. So, what decision did Justice Tadding end up making? Excuse me. He withdrew from the case. He recused himself. That's a technical word. He said, I can't decide and I won't decide. I'm not going to vote for either affirmance or reversal of the conviction. He made no attempt either to interpret the statute or to apply it. He was so disgusted. It's as though he was so disgusted he didn't want anything to do with this case. So let's look a little bit at what he said near the end. He says, at page 631, I've given this case the best thought of which I'm capable. I have scarcely slept since it was argued before us. When I feel myself inclined to accept the view of my brother Foster, I'm repelled by a feeling that his arguments are intellectually unsound and approach mere rationalization. Let me stop right there. Mere rationalization, that's that result-oriented jurisprudence I've been talking about. Justice Tadding is implying or suggesting that Justice Foster arrived at a conclusion first about what should be done with these defendants, and then simply rationalized it by coming up with arguments to support it. So that's what he means right there. He's accusing Justice Foster of engaging in result-oriented jurisprudence, which is disreputable. Okay, continuing. He says, on the other hand, when I incline toward upholding the conviction, I'm struck by the absurdity of directing that these men be put to death when their lives have been saved at the cost of the lives of 10 heroic workmen. Now, what he's talking about there is one of the facts of the case. While the rescue effort was underway, an accident occurred of some sort. I can't remember the details. And 10 of the workers who were trying to rescue the spelunkers died. So Justice Tadding seems to be saying that we've already lost 10 men plus Wetmore. Do we really want to compound the misery by putting these men to death, 4 additional men to death? He says, it is to me a matter of regret that the prosecutors saw fit to ask for an indictment for murder. If we had a provision in our statutes making it a crime to eat human flesh, that would have been a more appropriate charge. If no other charge suited to the facts of this case could be brought against the defendants, it would have been wiser, I think, not to have indicted them at all. So he's saying it would have been nice to have a lesser offense punished much less severely than death. And if there were no such lesser offense, then probably it would be better that these men be released altogether rather than put to death. As between death and letting them go free, Justice Tadding says, I'd let them go free. He says, unfortunately, however, the men have been indicted and tried, and we have therefore been drawn into this unfortunate affair. Darn it. I wish things had gone otherwise, but we find it is what it is. We're here now. We're faced with this awful case. We've got to make a decision, one way or another. Neither decision is acceptable to Justice Tadding. So what does he conclude? He says, since I've been wholly unable to resolve the doubts that beset me about the law of this case, I am, with regret, announcing a step that is, I believe, unprecedented in the history of this tribunal. I declare my withdrawal from the decision of this case. Wow. Now, if you read that article by Fred Schauer, he suggests that that's unacceptable. A judge is sworn to rule in cases, including this one. Judges don't get a pass to withdraw from any case that makes them uncomfortable. Justice Tadding should have done what a judge is required to do, and that is make a decision. So Fred Schauer, the author of that optional reading, thinks that this is criticizable, that what Justice Tadding is doing here is unacceptable. But he did it anyway. So where are we in our discussion of the case? 3 of the 5 justices have issued rulings, 1 for affirmance, 1 for reversal, and 1 who withdrew altogether from the case. So we're getting closer to an ultimate ruling in this case. We have 2 opinions to go, and we'll discuss both of them Thursday, later this week when we wrap up the article. The 2 we'll be discussing are Justices Keene and Handy. So make sure by the time you turn on my video for that final lecture this week, later this week, make sure you've read the entire article slowly and carefully. And also look over my lecture notes, and you'll see where I'm going in our discussion. Okay, that's enough for today. We're 1 hour and 6 minutes in. I'm going to get this posted. I'll send you an email when I'm done. And again, I'll see you later in the week for the second lecture. So long.